Hired her to help raise your child. She eats dinner with your family. She lives under your roof. She becomes part of your home until one day you discover your biggest threat wasn't outside your marriage. It was living inside your house. This is the au pair murder trial. But before I tell you what investigators uncovered, I want to put you in their shoes, because every case begins with only fragments of the truth. So, welcome to You Be the Judge. In every case, there comes a moment when the evidence is incomplete. The answers aren't obvious, and everyone has an opinion. I'm going to give you only the facts investigators had at the beginning of this case. No hindsight, no verdict, no speculation. You decide what you think happened, and then we'll compare your verdict to what investigators ultimately uncovered. You be the judge. A 911 call comes in. A toddler is found unharmed in the basement. An unknown man lies dead down upstairs, 2 gunshot wounds to the head. The wife is barely alive with 7 stab wounds to the neck. The au pair is frantic. The husband claims it was a random home invasion and says he was grabbing McDonald's when it happened. Then investigators hear something else. The husband says he walked in while the intruder was stabbing his wife, grabbed his firearm, and shot the attacker. What's your verdict? Most people think the hardest part of a bad marriage is leaving it. We talk about the financial hit, the legal battles, the sheer terror of starting over. But what happens when someone is so terrified of divorce that they'd rather commit a murder than a settlement? On paper, this case looked like a straightforward divorce. 1 child, 2 W-2 wage earners, and 1 family home. In the legal world, that's as straightforward as it gets. But court documents only tell you what people own, not who they are. We're diving into what happens when a seemingly simple divorce collides with a blurred household boundary, a live-in helper from Brazil, and a betrayal no one saw coming. Because when a marriage starts fraying, the real danger may be who you're letting sleep under your roof. Let's get into it. If you pulled up the legal filings for the Banfield family in Herndon, Virginia, back in 2023, you'd see a textbook suburban life. 2 solid W-2 incomes. Brendan was an IRS special agent, and Christine was a dedicated pediatric ICU nurse. They had been married for 13 years, together for 19, 1 single family home, 1 4-year-old daughter. On paper, if they filed for a divorce tomorrow, it's a standard, uncomplicated split. But Brendan didn't want a standard split. He didn't want child support calculations, alimony debates, or a divided bank account. Enter the 22-year-old au pair, hired from Brazil to live in their home and care for their daughter. Within months, the boundary lines erased completely. Brendan and Juliana began an affair right under the wife's nose. But instead of serving divorce papers, Brendan built a trap. Using his wife's laptop, he set up a profile on FetLife, which is a sex fetish website. He spent months massaging a 39-year-old stranger named Joseph Ryan, luring him to the house under the false pretense of playing out a violent BDSM rape fantasy. On the morning of February 24th, Brendan sits parked outside a local McDonald's, phone in hand. At 7:37, his phone rings. It's the au pair inside his house. He's here. Joseph Ryan walks into the master bedroom, expecting a consensual fantasy. Instead, he walks into a double execution. Brendan rushes home. The wife is stabbed 7 times in the neck, 2.5 inches. Joseph Ryan is shot dead Their 4-year-old child is downstairs in the basement. Then comes the 911 calls, 3 in total with 2 hangups. Brendan gets on the line and says he just walked in on an intruder, stabbing his wife and shot the intruder in self-defense. It was framed as a hero husband protecting his family, but digital forensics, blood splatter patterns, and a hidden cell phone pulled the curtain back. The ultimate twist, the au pair turned. Juliana took a plea deal for manslaughter and took the witness stand against her former lover. In February of 2026, a jury convicted Brendan on all counts of aggravated murder. A case that looked like a 1-house, 2-income divorce on paper ended with 2 people dead, 2 lives ruined, all because someone decided murder was cheaper than a divorce settlement. When marriages break down, people have choices: counseling, separation, divorce, mediation, honest conversations, even walking away. You have more options than you think. Attorney negotiations, mediations, mandatory settlement conference, daily settlement officers, private judge options such as jam, signature resolution, retired judges. So what would a divorce actually have looked like? Property division, child support, spousal support, if applicable, attorney fees. Those are difficult conversations, not reasons to take a life. None of those choices are easy, but they're lawful. The tragedy in so many of these cases isn't simply that someone died, it's that someone rejected every lawful path that existed before violence. To the outside world, they look like a successful family, children, careers, a beautiful home, an au pair living with them to help care for the kids. Nothing appeared unusual, but inside that home, another relationship was quietly developing. Most people think this story is just about an affair. I don't. I see it as a story about deception and the consequences of living a double life, because affairs don't begin the day someone gets caught. They begin the day someone decides to start living 2 completely different lives. As a family law attorney, I often hear people say, "I don't even know who I married anymore." That statement usually comes after years of discovering hidden bank accounts, secret relationships, lies, and broken trust. This case simply takes that question to its most horrifying extreme. Let's do the red flag countdown. Red flag, living a double life. Red flag, emotional intimacy shifting outside the marriage. Red flag, increasing secrecy. Red flag, the spouse becoming an obstacle instead of a partner. Red flag, someone else becoming more important than protecting the family. Extensive unexplained travel, phone always face down, passwords suddenly changing, emotional distance, lies that become easier to tell, someone outside the marriage becoming the emotional priority. Here's what people need to understand. Divorce is not necessarily a 5-year war. In California, there is a mandatory 6-month waiting period before you can legally terminate your marital status. That does not mean every divorce takes years. An uncontested divorce can be shorter. The waiting period is just paperwork, disclosures, and a proper agreement. Even when the parties disagree, a full-blown trial is not the only option. 90 to 98% of divorces are resolved without a complete trial. Why? Because family court gives people multiple opportunities to settle. Negotiations, private mediations, voluntary settlement conferences. The court can order all kinds of things before, you go to trial. In Los Angeles County, experienced family law attorneys serve as daily settlement officers and help parties resolve, all kinds of issues, sometimes at no charge to the litigants. The parties can hire a private mediator. They can retain a retired family law judge through JAMS or Signature Resolution or another private dispute resolution provider. They can spend an entire day working through, their issues and deciding, tough disputes. And sometimes settlement doesn't happen all at once. You may settle custody first and then the house next. You may narrow 20 issues down to 3. Progress is still progress. But, I'm not going to sit here and pretend divorce is easy. It is emotionally painful. It can be financially draining. It can involve betrayal, fear, anger, custody disputes, and dismantling a life that was once together. It is a tough process. But tough is not impossible, and tough is not a justification for murder. There were legal doors available. There were lawyers, judges, settlement officers, and mediators available. There were lawful ways to end the marriage, divide the property, determine support, and establish custody. A marriage can end without destroying everyone connected to it. That's why I always say marriages should end in family court, not criminal court. Family court may divide your assets, your debts, and your parenting time. But criminal court, it can take away the rest of your life. Let's see how criminal court worked out for Mr. Banfield. He took the stand. His testimony was about as convincing as his murder plot. This case instantly brought me back to another murder trial I covered. Completely different facts, completely different people, but driven by the exact same arrogance, the lethal belief that you are the smartest person in the room. Just look at this plan. Set up a fake fetish profile under your wife's name, lure a complete stranger with a knife to your house, stash your 4-year-old daughter in the basement by herself, wait down the street at a McDonald's until the trap is sprung, then race home to discover a home invasion, execute the stranger, and play the grieving hero husband with the 21-year-old au pair from Brazil standing by your side. A plot like that relies on one massive delusional assumption that everyone else is too stupid to ask questions. Time and time again, I see defendants do this. They scramble to hit delete on incriminating messages, completely oblivious to the fact that digital forensics will recover every single byte. They forget that Ring cameras aren't just watching, they're recording, capturing private, incriminating conversations that will tank a defense strategy faster than any prosecutor ever could. And worst of all, they forget the most dangerous variable in any conspiracy, the person standing next to them. They rely on this young au pair to stay silent, forgetting that when life sentences are on the line, loyalty evaporates and accomplices turn state's evidence. The lesson isn't that someone outsmarted the system. The lesson is that arrogance makes people careless. You aren't as smart as you think you are. And in a world full of Ring cameras, cell towers, pings, and recovered text, your own ego will convict you every single time. One of the biggest decisions in any criminal trial is whether the defendant should testify. Sometimes taking the stand is exactly the right decision, but other times, it's the moment the prosecution has been waiting for. Why? Because the moment a defendant takes the oath, everything changes. Every answer, every detail, every inconsistency, every pause, every word is tested. And that's exactly what cross-examination is designed to do. Cross-examination isn't about asking easy questions. It's about stress testing a witness's version of events against the evidence, the prior statements, and simple common sense. If your account is truthful, it should withstand that level of scrutiny. If parts of your story are inaccurate or fabricated, cross-examination has a way of exposing the cracks. Watching Brendan Banfield testify, I couldn't help But think about that. According to his testimony, after shooting Joseph Ryan, he rushed to his wife, Christine, pulled her into his arms, and described what he claimed were her final moments. He testified that she looked at him and said, "B, what happened? Why did he do this to me?" From a trial strategy standpoint, those words were very important. If believed, they painted Joseph Ryan, the alleged intruder, as the lone attacker, Banfield as this grieving husband, and suggested Christine had no reason to suspect her own husband. But then came the medical testimony. The prosecution presented expert evidence that Christine suffered multiple deep stab wounds, including injuries that severed her carotid artery and jugular vein. Those experts testify that she would have lost consciousness almost immediately. The jury had to decide whether Banfield's account could be reconciled with that medical evidence. And that's what credibility is all about. It's not enough for a story to sound convincing. It has to withstand cross-examination. It has to withstand expert testimony. It has to withstand the physical evidence. As trial lawyers, we don't evaluate testimony in isolation. We compare every word to the objective evidence, because physical evidence doesn't rehearse, it doesn't embellish, it doesn't change its story. Sometimes the most damaging evidence isn't introduced through another witness. Sometimes it's revealed during a witness's own testimony. Here's my verdict. Cross-examination doesn't create the truth. It reveals whether a witness's story can survive being tested. And in the courtroom, credibility isn't measured by how confidently someone tells a story. It's measured by whether that story still stands after every question has been asked. Benjamin Banfield didn't do very well. He was literally destroyed by the prosecution. At sentencing, the judge imposed the harshest sentence available. In explaining its decision, the judge described him as a man who believed he was the smartest in the room. That observation stayed with me, because if the prosecution's evidence proved anything, it was that the alleged plan depended on one extraordinary assumption, that everyone else would believe the story without asking questions. But what struck me even more than the judge's description of the victim's final moments was, she said the wife believed her husband was coming to save her, and instead watched her husband repeatedly stab her in the neck. The man they lured to the home was then shot, and after he was already helpless, they shot him again. Those aren't just horrific facts. They explain why the court concluded that life without parole was the appropriate sentence. As a family law attorney, I spend my career helping people navigate the end of the relationship through the legal system. This case is a reminder of what can happen when deception replaces honesty, when entitlement replaces accountability, when people believe they are the smartest in the room, because the smartest person in the room isn't the one who thinks they can outsmart everyone else. It's the one who understands that every lie tells a tale, and that truth has a way of catching up. You know, one of the hardest conversations I have with clients isn't about dividing property. It's when they look at me and ask, who is this person I married? Not because they suddenly changed, but because the truth finally surfaced. If you're looking for retribution for wounds the law was never designed to heal, you will be disappointed. The court can divide property, determine custody, award support, issue restraining orders when the legal standard is met, enforce judgments, but the court cannot restore trust. Can't make someone tell the truth. Can't make someone love their spouse again. Can't undo betrayal. Can't give emotional closure. One of the most fascinating parts of any trial isn't just the evidence, it's the witness. People spend months preparing for trial. Lawyers prepare exhibits, witnesses, rehearse testimony. Everyone walks into the courtroom hoping to tell the most convincing story. But then they take the stand, and something interesting happens. The courtroom has a way of stripping away the performance. Sometimes a witness strengthens their own case. Sometimes they slowly unravel it. Watching this defendant testify, I kept thinking about a lesson I've learned after years in court. You can't rehearse credibility. You can rehearse answers. You can rehearse body language. You can rehearse a story. But credibility is something different. Sooner or later, it reveals itself. That's why experienced trial lawyers don't always feel the need to interrupt every answer. Sometimes the most persuasive testimony isn't the answer the lawyer uncovers. It's the answer the witness volunteers. There's an old courtroom lesson that has stood the test of time. Never interrupt someone who's damaging their own credibility. Not because you want anyone to fail, but because credibility can't be manufactured. It has to be earned. And eventually, the witness stand reveals it. The witness stand doesn't create character. It reveals it. The strongest witness isn't always the one who says the most. It's the one the jury believes, the judge believes. And those are not always the same person. One of the hardest things I tell clients is this. The law can resolve legal disputes. It cannot heal emotional ones. Family court can divide a house. It cannot repair a broken heart. It can allocate debt. It cannot erase betrayal. It can end a marriage. It cannot explain why someone chose to destroy it. When Brendan Banfield took the stand, he tried to present his refusal to divorce as devotion. He claimed he loved his wife and wanted to preserve his family. But staying in a hollowed out life out of fear, greed, or control isn't love, it's cowardice. Banfield chose a monstrous plot because he was terrified of the fallout of an honest exit. He feared the split assets, the lost status, the bruised ego. He couldn't summon the strength to step into the unknown, so he chose destruction instead. What so many people forget is that choosing to walk away isn't an admission of failure. It is an act of profound courage. In my work, I see people walk into my office every single day who prove what real strength looks like. They look me in my eye and tell me they are willing to walk away with nothing, to surrender the house, the savings, the material comfort, just to have peace, just to shed the dead weight and finally be free, because they understand something the coward never learns. You can rebuild wealth, but you can never buy back time or a broken spirit. It takes genuine bravery to look at a broken situation and say, I deserve peace, I want better, and I am willing to pay whatever price it takes for my own happiness. Moving on isn't giving up. It's choosing life over slow emotional decay. In law and in life, people constantly measure the financial and emotional damage of a split. They tally up the legal fees, the divided lives, the lost pride. But as this courtroom proved, they rarely consider the cost of refusing to accept the end, because sometimes the most expensive decision a person can make isn't getting divorced. It's refusing to. I'm Joni Solomon, and this is On One.